this period in American constitutional history. If it weren't for the fact that we're adopting this historical chronological approach, frankly, I would far rather have skipped it. However, all that being said, the issues that are raised in the period, however I might feel personally about the way they were worked out, are issues that existed before and continued to afterwards. And so what happens in this period is very important as a step in the development of what will eventually become our modern understanding of the US Constitution. A couple of quick points at the beginning. So in 1837, the Judiciary Act is adopted. Remember, there was the 1789, there was the 1802. Right? This is yet another Judiciary Act, yet again reorganizing the courts, this time to ensure a permanent pro-slavery majority on the Supreme Court. At this time, the way the Supreme Court works is there's one justice from each circuit, and so the 1837 Act ensures that there's a majority of southern circuits, 5 southern, 4 northern. When California is added as a state, it then gets a 10th Circuit, but in order to preserve the pro-slavery majority, California's 10th Circuit does not get a seat on the US Supreme Court. So from 1837 forward, even if this weren't true before, the Supreme Court is a pro-slavery veto point, meaning any effort to use, for example, congressional authority under Article 1, as was feared by Calhoun, right? And if they can build canals, they can abolish slavery, remember last time? And of course, that fear goes back much earlier. We saw it in some of the anti-federal, not all, but some of the anti-federalist writing as well. Any attempt like that will be foreclosed by the US Supreme Court, applying its interpretation of the scope of federal powers. Similarly, any attempts to do things at state levels or through legal action are likely to be stymied. It's not the only veto point. It's also true that due to the 3/5 clause, the South has a lock on the presidency. All presidents from Jackson until Lincoln are pro-slavery. They're all pro-slavery, basically pro-slavery Southerners. One of them is not a Southerner, but they're all staunchly pro-slavery. So there are multiple veto points, but our concern about the Constitution, right? This isn't. We talk about American politics in terms of the setting that it creates. For constitutional development, in terms of constitutional development, this is the period in which the issue of slavery, which was always, as I've tried to point out, always behind everything from internal improvements to the scope of national powers, really becomes front and center. What else? Oh, right. So another question has to do with, and I'm sorry, this is stuff that the authors cover on pages 189 to 192, the sort of background before they dig into the period. The other issue that the authors point to is departmentalism. Now, that's actually a little bit of a misnomer. I hate correcting the authors of our own textbook, but really what they're pointing out is 2 different issues. One is departmentalism, and then one is what might be called popular constitutionalism. Departmentalism is the idea that each of the branches of the federal government has independently the authority and the responsibility to interpret the Constitution. Just as a basic definition, I'll leave it at that. I'll come back to it as we get to it in the lecture materials and point to some of the potential problems that can arise, but that's one argument, and you might recall Jefferson, for example, was a pretty strong departmentalist. Popular constitutionalism, which doesn't necessarily contradict departmentalism at all, it's just different, I mean, they're sort of different axes, so to speak, is the idea that the authority to interpret and define the Constitution should rest at all times with the people. So what these 2 things have in common, so let me read you a couple of quotations. Here's Jackson, 190 on the right. Jackson ran for president in part on a platform opposing the National Bank. He was elected, and he said he considered his re-election a decision of the people against the bank. Van Buren, a Jacksonian president who follows, if different interpretations are put upon the Constitution by the different departments, the people themselves through the ballot box must settle it. So you can see how departmentalism and popular constitutionalism go together. If you say each department has independent authority to determine the Constitution, well, then who judges? And for these guys, these small d democratic Jacksonians, the answer is the people, the election. If the people approve of, for example, the president's constitutional vision, they will re-elect him. If they don't, they won't, and that's how we'll know. It's very similar. I mentioned this really, really briefly in passing. I don't expect anyone to remember it, but it's quite similar to the British model of parliamentary supremacy, which says there can be no external or legal checks on what Parliament can do. the only check is popular will. If the people are outraged, I exaggerated slightly when I said if they rise up and revolt, well, I guess we did something wrong. And if the people don't express their outrage, then it's okay. So these two, departmentalism and popular constitutionalism, have in common that they reject the Marshallian federalist model of judicial supremacy, but they're not perfectly identical concepts. All right, both of them will arise as we go through some more detailed issues in the remainder of the lecture. We'll get to see a little more deeply what's going on. So what are some of the constitutional issues that do arise in judicial proceedings or constitutional controversies? The first is the political question doctrine, a concept introduced in Marbury. Questions that are by their nature political are no part of the court's authority, right? I call this the we do law theory. I said the courts narrowed the scope of their authority in order to strengthen it. We only do law, we don't do politics, but we have the final say over law, right? And then politics is just left to somebody else, and there's this nice, artificially neat separation. And I mentioned to you that one of the consequences of this idea, as it becomes fully fledged into what's called the political question doctrine, is that chunks of the Constitution, potentially significant chunks of the Constitution, are outside the scope of judicial enforcement or legal argument. Now, let's be clear what that means. Remember that Marshall grandiloquently declared that it is the essence of civil liberty that anyone whose rights are violated can find a remedy in a court. That was grandiloquence and not real because, as we're about to see, in fact, there are large chunks of the Constitution that seem to secure rights or prerogatives, the violation of which does not trigger access to any remedy in a court, which in fact was true in Marbury as well, but only by way of a procedural, right, jurisdictional, kind of complicated game. So Luther versus Board, I love this story. I mean, this is, if we cover anything that you go look up on Wikipedia, just to learn more about it, this should be it. So 1841, Rhode Island is still operating under its 1663 charter. It's no longer a royal charter. When they became a state, after the Declaration of Independence, they simply made the charter their constitution. Under the charter, only landowners can vote, and the districts are drawn in such a way as to heavily favor rural interests. By the 1840s, what are we talking now? 180 years later, this has become intolerably inconsistent with the reality on the ground. So there's a big popular convention, the Constitutional Convention. They hold the Constitutional Convention, they adopt the new Constitution. Under the new Constitution, they hold elections, and they elect Samuel King. The problem is, the existing government refuses to recognize the legitimacy of the Constitutional Convention. I mean, what would happen? We keep talking in the United States today, we should have a Constitutional Convention. What if we had one, and then the existing national government said, nah, we don't accept it? Then what? Right? I mean, that would be an interesting situation. That's exactly what happened in Rhode Island. But it got quite heated because the Dorr, this is known as Dorr's Rebellion. Sorry, the new convention elected Thomas Dorr. I switched the candidates. Thomas Dorr is the guy elected under the convention with the new constitution. The existing government then holds its own convention, reaffirms the existing constitution as it is, and elects Thomas King. So you have two different people claiming to be governor of Rhode Island. King declares a state of emergency and sends out troops to arrest Dorr's supporters. And that's how this lawsuit arises. One of Dorr's supporters, a guy named Luther, if I'm not mistaken, yep. One of Dorr's supporters, this is Dorr's Rebellion it's called, a guy named Luther is arrested by an officer named Borden. He sues, claiming that Borden had no legal authority to arrest him. So the question for the court is, did Borden, so remember Borden is the officer acting on behalf of King, the conservative candidate from the existing government's system, did Borden have the authority to arrest Luther, meaning was the King administration legitimate? Which of these two administrations under the Constitution is the government of Rhode Island? And specifically, Luther challenges the King administration. Is everybody following this? I know I switched the names at the beginning, but we get the King and the Dorr. Luther challenges the King administration by saying its existence violates the Republican Guarantee Clause, the clause of the Constitution that says Congress shall guarantee to all the states a Republican form of government. Luther makes the argument that the 1663 Charter and the military law. It was essentially a military dictatorship during the period of emergency that King announced are contrary to Republican principles. Taney's answer is, we're not going to touch that with a 10-foot pole. This, says Taney, is a political question. It is not a question arising under the Constitution, which, if you recall, is the scope of the jurisdiction of the federal courts. So don't lose sight of what's going on here. In order to say, as Taney's about to say, says and is about to say, in order to reach the conclusion, the Supreme Court concludes this is a political question. It is not one the courts can address. Article 3 says the courts have jurisdiction over any question arising under the Constitution. This is the first of a number of points you're going to see where the courts deliberately push away authority. It's the same move as in Marbury. In order to keep the security of the authority they have, they will disavow authority over other things, including what, when we read the text of the document, looked like a pretty important piece of the Constitution. All right, what is Taney's argument? First, a pragmatic argument. To declare the existing government, the King government, illegitimate would create massive chaos. If this court is authorized to enter upon this inquiry, and it should be decided that the charter government had no legal existence during the period of time above mentioned, then the laws passed by its legislature during that time were nullities. Its taxes wrongfully collected. It's almost Shakespearean, isn't it? Its taxes wrongfully collected, its salaries and compensations to its officers illegally paid, and the judgments and sentences of its courts null and void. Right? If we declare that the King administration was a void administration, then everything it did during this period is void, which would be obviously chaos. You should see where this is going, right? What about everything that was done by the Confederate States during the Civil War? After the war was over, right? The Union wins, the Confederacy surrenders, it's all over, yay. What about marriages that were performed by Confederate judges? Are they valid? Or debts owed to the Confederate government or from the Confederate government, or just debts incurred using Confederate currency? Remember, they had their own currency, right? I will sell my horse to you for 100 Confederate dollars. Is that an enforceable contract after the end of the Civil War? So this is a weird kind of warm-up. I mean, not that Taney saw that coming, but this is a weird kind of warm-up to what's going to become a gigantic question at a later period. Right now, Taney's saying, but notice what his argument says. The chaos only arises if the court were to declare that the King administration is invalid and give that retrospective effect. In other words, he's being a little bit disingenuous. The court could perfectly well declare the King administration invalid and say, but this is only a prospective judgment. It doesn't affect things that happened before. The court might rule in favor of King, in which case there'd be no problem. So he's pointing to one possible outcome, the one the plaintiffs desire. And rather than say, see, this outcome will be so disastrous, we can't give them their victory, he says, this outcome will be so disastrous, we can't address the question. Which is an interesting move, the first of several. Second, it's a political question assigned to other departments. And indeed, make no mistake, the Republican Guarantee Clause, as we saw, says Congress shall guarantee to the states a Republican form of government. Right there in the text, it says Congress. Therefore, says Taney, that means this is Congress's business. Constitution of the United States, as far as it has provided for an emergency of this kind, and authorized the general government to interfere in the domestic concerns of the state, has treated the subject as political in nature and placed the power in the hands of that department. Republican Guarantee Clause says Congress, it's Congress's business. This is called a textual commitment. This is a question that is textually committed to a branch other than the courts. But that's not his only argument. Furthermore, he says, consider Article 1. Under Article 1, Congress makes its own rules, right? Including rules for whom to seat as congressmen. Imagine a state sent two different groups of congressmen, each claiming to have been rightly elected. Congress would have to decide which group to seat and which one to reject. In so doing, says Taney, Congress is taking up the responsibility of determining which is the legitimate and hence the Republican government. When the senators or representatives of a state are admitted into the councils of the Union, the authority of the government under which they are appointed, as well as its Republican character, is recognized by the proper constitutional authority. This ties into the first point. It's Congress's job to guarantee a Republican form of government. Therefore, when Congress seats representatives, that must mean Congress finds that government to be valid. So it's up to Congress to decide which is the appropriate government of Rhode Island. But that's not all. It's also up to the executive. Anybody but the courts. Why is it up to the executive? Remember the militia powers? Right? The militia can be called forth to put down insurrections. Well, if the militia were called forth by the president to put down Dorr's rebellion in Rhode Island, which side would it choose? And whichever side the president chooses, that means he, the president, has decided that's legitimate government. And under the Constitution, our insurrection is specifically mentioned. Under the Constitution, as commander-in-chief, the president can call up the militias, as Washington did in response to the Whiskey Rebellion in Pennsylvania. So we have precedents of practice as well as theory. The president can call up the militia and put down the insurrection, and in doing so, he chooses sides. After all, would you really want a court to second-guess the president and say you chose the wrong side? After the president has acted and called up the militia, is the Circuit Court of the United States authorized to inquire whether this decision is right? If the judicial power extends so far, the guarantee contained in the Constitution of the United States is a guarantee of anarchy. And that's basically his argument. This is a political question because each of the other branches is called upon to answer it. The president has to answer the question, which is legitimate government of a state, when he calls up the militia. The Congress has to answer the question, which is the legitimate government of a state, when they seat representatives. This, says Taney, proves this is not a question for courts. It's not a constitutional question that can be enforced through a judgment. Everybody understand the argument? It's not very complicated. There's a gaping hole in it. Can anybody think about Chisholm? Courts also have to decide which is the legitimate government of a state if that state sues another state. Imagine the King administration sues Massachusetts. If the federal courts accept that lawsuit, they're granting jurisdiction on the basis of their recognition of the King government. Taney is just lying. He's just flat out ignoring the fact that the question of recognizing which is legitimate state government has to be reached by courts. In order to determine diversity jurisdiction, this is a lawsuit at a federal court. Is it between two people who are residents of different states? The courts have to decide what the states are. Maine, when it broke off from Massachusetts, if you don't know this, Maine was once part of Massachusetts. When Maine broke off from Massachusetts, you can imagine a situation which is a debate about that. Is someone from Maine really a citizen of a different state than someone from Massachusetts? A federal court would have to decide that. But just take our current example here. If the King administration sues Massachusetts, a federal court has to decide whether that King administration is Rhode Island or not. So this is just, it's very, very obvious what's going on. Taney does not want the court to be involved in this. We do not, Taney does not, the same thing Marshall did in Marbury. We don't want to be part of this fight. We don't want to be caught at the apex of this kind of huge political controversy, so we will narrow the scope of the enforceable part of the Constitution in order to preserve our authority over the rest of it. Not the last time we'll see the political question doctrine, but certainly one of the more interesting. And as I say, the background story is just great. Dorr's Rebellion is a wonderful story. All right. Well, different question. We're hitting sort of a series of separate questions here. This isn't all one theme. These are just things that arose during the period. Different question. Do any of the rights in the Bill of Rights apply against the states? The answer is no. I've told you this before, but we have the Supreme Court saying so, just so you know I wasn't making it up. It's even Marshall, 1833. It's a Fifth Amendment claim. A property owner claims the actions of the government have reduced the value of his property, and he should be compensated. The Takings Clause, you're all familiar with the Takings Clause? Anybody have no idea what I'm talking about right now? Cool. So he says under the Fifth Amendment, he's entitled to compensation. Marshall doesn't say anything about the claim. He just says the Fifth Amendment doesn't apply to the states, nor the First, nor the Second, nor the Third, nor the Fourth, nor the Eighth. The Fifth Amendment must be understood as restraining the power of the general government, not as applicable to the states. In their several constitutions, they have imposed such restrictions on their respective governments as their own wisdom suggested. It is a subject on which they judge exclusively. And he goes on to argue, page 198 on the right, Only Article 1, Section 10, that list of things that are prohibited to the states, those are the only restrictions. Ex post facto clause, bills of attainder, titles of nobility, impairment of contracts. Those are the only constitutional limitations that limit what state governments can do. So to take everyone's favorite example, the right of freedom of expression, states are not required to respect freedom of expression until 1921. And when the court announces in 1921 that states are bound to respect the freedom of expression, it's hugely controversial. Prior to that time, based on Barron versus Baltimore, this 1833 precedent, and all the way up until the 14th Amendment, actually later, until the 1920s, it is simply not a thing to use a constitutional rights guarantee in the Bill of Rights or any other, or well, in the Bill of Rights, to limit the actions of state governments. Now, listening to this story, you should notice a gap. What happens? Let me jump ahead. In 1921 and later, when rights under the Bill of Rights are found to limit what state governments may do, it's because of the 14th Amendment. I presume you all know that, but let me just make it clear. Right, so prior to the 14th Amendment, none of the rights in the Bill of Rights apply to the states. After 1921, and then, various other rights in the 60s and 70s are added one at a time in the Bill of Rights. The most recent one was last year. This is still an ongoing process. But after 1921, we begin to say that rights, because of the Bill of Rights in the Bill of Rights, apply to limit the actions of state governments under the 14th Amendment. What happened in between? Why did it take 50 years to decide that the 14th Amendment means that there are rights that limit what states may do? We'll get to that, and the case is called Slaughterhouse. But right away, that lacuna in the story should jump out at you. Because clearly, something is going on, and you will not at all be surprised to learn that the US Supreme Court is at the heart of it. Back to our story. The bank veto controversy. All right, we went through this last time, right? The story of the bank. Just to refresh your recollection, 1791, a bank is adopted over the strenuous objections of Madison and Jefferson. This is Hamilton's great victory. The bank is chartered for 30 years. The charter expires. There's the War of 1812. They go for 4 years without a bank. They got war debts again. The whole thing starts over. They charter a new bank. Madison changes his mind in 1816. He vetoes in 1815, but approves in 1816. Jackson gets elected. Remember we just read that quotation from Jackson where he says, "My election is the people saying, screw the bank." Wanting to get ahead of that issue, Whigs in Congress proposed to recharter the bank early. It's still got 4 years to run in 1832. It doesn't run out until 1836, right? 20 years from 1816. It's still got 4 years to run, but they say, let's do it now. Let's do it's just a political move. It's not a stunt exactly, it's a political move. Let's recharter it for 20 years now. They do, and Jackson vetoes it. And Jackson's veto message is rightly considered one of the classic articulations of Jacksonian constitutional politics and Jacksonian constitutionalism. So let's see what he says. First, he appeals to departmentalism, the idea of shared responsibility among the different branches of the federal government. Congress, the executive, and the court must each for itself be guided by its own opinion of the Constitution. It is as much the duty of the House of Representatives, of the Senate, and of the President to decide upon the constitutionality of any bill or resolution, as it is of the Supreme Judges when it may be brought before them for judicial decision. Right, departmentalism. Everyone takes an oath to uphold the Constitution. Everyone in each of the branches has to fulfill that oath. Here's the interesting problem. Let's take two situations. Situation one, the federal court says, as the Supreme Court said in McCulloch, that the national bank is constitutional. The president says, well, I don't think it's constitutional, and therefore declines to sign a bill or vetoes it. That is not constitutionally problematic, is it? I mean, after all, the Supreme Court saying that the bank is constitutionally permitted is not the same thing as the Supreme Court saying that the bank is constitutionally required. The Supreme Court's decisions on questions of constitutionalism set a floor. This is what is allowed. Beyond that, It's a matter of policy. But what if you flip it? What if the Supreme Court said the bank is unconstitutional? And the president says, well, I think it's constitutional, and goes ahead and signs it into law anyway. In that situation, you have a direct confrontation, a direct challenge to judicial supremacy. And I want to call your attention to something, because in all of the examples of departmentalism that I have ever seen, including this one, people often like to say, oh, you go back in history and people didn't think the Supreme Court had the final word. That's true insofar as the situation was Congress or a president declining to do something the court said they could do. There are not cases, with rare exceptions, extraordinarily rare exceptions, one of which we'll see, in which presidents have undertaken to contradict the courts in saying, I will do something even though you have declared it unconstitutional. That we see in nullification. The states have asserted that authority. Departmentalists usually don't. Keep your eyes open for that. And watch out for the slip people sometimes make in modern arguments from the idea of departmentalism as the president should not do things that he thinks are unconstitutional, to the president should do things he thinks are constitutional even though the Supreme Court has said that they are not. Ever see the difference between those two? Okay. Just yet one more thing to keep your eyes open for as we go forward. Here, says Jackson, remember this is Jackson's veto message, he grants that in McCulloch, Marshall said the bank is constitutional, and he's not disputing that. What he's disputing is that the specific bill establishing the bank, in all of its details, is constitutional. He's not questioning Marshall's conclusion that the national government may make a bank, but that doesn't mean that this bank is constitutional. And what could be wrong with this bank? Well, for example, the original Act of Incorporation enacts that no other bank shall be established by any future law of the United States. It cannot be necessary or proper, right, the necessary or proper clause he's referring to, of course. It cannot be necessary or proper for Congress to barter away or divest themselves of any of the powers vested in them by the Constitution to be exercised for the public good. Part of this particular bank bill said there won't be any competing banks. There'll be one national bank only. Well, wait a minute, says Tawny. This is interesting slip. Says Jackson. That's one Congress binding the hands of a future Congress. Can't do that. It's not a thoughtless objection, right? And it raises a much bigger problem. The much bigger question, what in general are the limits on the ability of Congress to transfer its authority to somebody else? For example, this is framed in terms of one Congress binding the hands of a future Congress. It's about time, right? What if we're different? What if it were Congress giving power to the president? Giving too much power to the president, giving away, divesting, barter away or divest themselves of the powers vested in them. Is there a constitutional obligation on Congress to retain control over the powers, the legislative powers? And this is going to become the question of delegation. Is there a limit to how much power Congress may delegate to the executive branch? Here, that principle appears in this time-bound form, but don't fail to recognize the implications for separation of powers. Furthermore, says Jackson, the way the bank is set up is that it relies on using private banks that then serve as National Reserve banks. Under McCulloch, remember, Maryland could not tax the Bank of the United States. That means that this law is creating a class of tax-exempt private corporations. That can't be right, says Jackson. He doesn't really explain why it can't, but he clearly feels that it can't be right. The principle is conceded that the states cannot rightfully tax the operations of the general government. But will any man maintain that their mere selection to perform this public service for the general government would exempt the state banks and their ordinary business from state taxation? And he goes on to say, supposing the bill had simply said, we identify these 5 existing private banks, we now declare you to be national banks, would they suddenly be free from all state taxation? Jackson says that can't be right. And the bigger issue, of course, in Jacksonian politics is the fear of corruption. This bank, says Jackson, is an instrument of the wealthy, the corporations, the businesses, and it is to be resisted. And as I read this to you, is it a constitutional argument? It's not a legal constitutional argument. It's not the kind of thing we usually think of as constitutional law, but it's certainly got everything to do with the Jacksonian vision of the kind of democratic polity the Constitution was supposed to create. It is to be regretted that the rich and powerful too often bend the acts of government to their selfish purposes. Distinctions in society will always exist under every just government, but when the laws undertake to add to these natural and just advantages artificial distinctions, to grant titles, gratuities, and exclusive privileges, to make the rich richer and the potent more powerful than the humble members of society, who have neither time nor means of securing like favors to themselves, have a right to complain of the injustice of the government. This is the idea of class legislation. Legislation that benefits one economic group over another one. Usually the rich over the poor. And under this objection, this is why Jacksonians objected to corporations and banks. Do you all understand how corporations are privileged to make money in ways nobody else can? Right? They live forever. Their owners don't have any liability for their bad acts or their debts. They can dissolve and reform in the same place 1 minute later and instantly have abolished everything they owed to anybody. They can be in multiple places at once. They're taxed wildly differently and wildly less than private individuals or partnerships. All of these things make corporations privileged forms of wealth. Originally, in this period, the justification was, well, they're providing a public service of some kind or another. It's a corporation to build a bridge. It's a corporation to operate a university. It's a corporation to be a city. As this gets to be railroads and then general business corporations, from the Jacksonian point of view, you're just picking out certain economic actors and you're using the law to privilege them. They don't have to pay their debts. They don't have to pay for the harms that they cause. Their ownership is separated from their control. They're immortal. They never have to go through probate. They can be, their residence is wherever they say it is. Yeah?
Just like, I'm still like a little fuzzy on it. So are they saying that basically like the banks would be funding these like internal improvements, but that the banks would be getting their money from like wealthy people, so that's why the wealthy people?
It's a little more complicated than that, but yes. So Jackson's concern about the bank as a tool of the rich is that if there is a national bank, not taxed by the states, first of all, it has advantages. It will then make loans. The loans can be used for these kind of investments that I'm talking about, which will make the rich richer, et cetera, et cetera, et cetera, et cetera, et cetera, right? And the federal government is therefore underwriting this process of the creation of corporate capitalism, which is exactly true, but of course, from the Whig perspective, yeah, but we need that. We need that to build railroads across the nation and to build canals and universities and observatories and improve. This is an engine of progress. This is right? Exactly the Jacksonians. And this is why, going back to Kramnik, it's not at all wrong. It is absolutely not wrong to describe Jacksonians as nostalgic, fearful of newfangled ways of doing things contrary to the values, the traditional values, the yeoman farmer, the kind of Jeffersonian virtues of independent individuals, and being subsumed under these new economic forms. And that's exactly right. So there were, like in Michigan and Ohio, there were farmers' wars where they tore up railroad tracks and burned down depots because the railroads were viewed as a threat to their way of life. That's a classic Jacksonian moment right there. So yeah, this is a basic conflict of political economy and interests, right? But it's being carried out in terms of a constitutional fight. And the constitutional fight is, does the federal government under Article 1 have the power to be an agent for changing the political economy? Is that an appropriate role for the federal government? That question, what is the appropriate limit of the national government's role in the economy, is huge and continues to this day in different ways. This is one of its first really strong articulations. Does that help? Why don't we stop here and go home? Or we could do the rest of the lecture, which is about Dred Scott versus Sanford. Okay, let's talk about Dred Scott versus Sanford. I hate teaching this kid. Sorry. All right, Dred Scott. You presumably all know the story. The slave owner took his slave into a free state. Once he was in a free state, he was declared a free man, dragged him back to Missouri where he was a slave again. He said, nope, I was freed, therefore I can go to federal court and sue to not be a slave anymore. The legal question was not reached. The question was addressed at the level of jurisdiction. For purposes of federal court jurisdiction, was this even trying to describe the guy becomes contentious. Was this one-time slave, one-time freed, now re-enslaved person a citizen of a state other than Missouri, the state in which he became freed? Everybody got it? We don't care. What you care about, what Tony cares about, what the Supreme Court cares about, is a much more subversive question. Can any ex-slave, freed slave, or the descendant of any slave be a citizen for purposes of Article 3 jurisdiction? Now, why is that so explosive? Don't take this wrong, but who cares? Well, supposing I am the child of a freed slave. If I can go to federal court, and I live in, pick it, I don't care, Ohio, free state, I live in Ohio. My parents were slaves in Georgia. If I can go to a federal court and sue someone in Georgia, I can sue their owner for harms that I suffered because of the way he acted as the owner of these slaves. And that's the end of the world. Dred Scott is the point where it was no longer possible to escape the fundamental contradiction between a system of federal courts enforcing the national constitution and a system in which some states permitted slavery and some states didn't. The only way you can have slavery in some places and not in others is to make it not a federal question. It has to be purely a state matter, one over which the federal courts, the Congress, the president have no authority whatsoever. Because if there's any opening to bring federal authority to bear on any question about that, one way or the other, it's going to be decided. So, the issue got more complicated because Dred Scott, the slave in question, wasn't taken to a free state, he was taken to a free territory. One of the territories in which Congress had banned slavery. Question, can Congress ban slavery in the territories? The Constitution says Congress shall make all needful regulations for the governance of territories. Areas owned by the federal government, not yet states, right? Can they ban slavery? There were 4 different arguments to say why they couldn't. One, the idea that territories were common properties of the states. Therefore, the ban on slavery would have the effect of economically burdening, and thus excluding citizens from slave-owning states, and that would violate the shared ownership, the federal shared ownership of the territories. 2, there's no congressional power on this question. Congress's power simply doesn't extend to things like property law. 3, due process. If you travel with your slaves into a free territory and they become free, then you have been deprived of property by the federal government without due process of law. Fifth Amendment certainly applies to Congress. 4, popular sovereignty. The people in the territories should be able to decide whether they will have slavery or not have that imposed upon them by the Congress. And there's a separate question that arises: what happens when those territories become states? Calhoun, as always the leading and most eloquent spokesman on behalf of slavery, says that there are 2 constitutional issues that decide these questions. One is the compact theory. If you accept the compact theory, then the federal government cannot possibly have power to ban slavery. Resolve that the government was instituted and adopted by the several states of this union as a common agent. It is the solemn duty of the government to resist all attempts by one portion of the union to use it as an instrument to attack the domestic institutions of another. Right? There isn't one national people. This is a compact among states. And therefore, it would be a violation of the authority given by those states to the national government, for the national government to take a position that favors some states over others. 2, the equal footing doctrine. So, thus far, I framed the question in terms of, does Congress have the power to ban slavery in the states? In the territories, excuse me. It gets to be a worse or more difficult question when those territories become states. By the Missouri Compromise of 1820, they would enter the Union as either slave states or free states. In the Kansas-Nebraska Act, the Compromise of 1850, right? You all know these compromises from your AP history classes? Well, hang on a minute. How can you say they're full-fledged states but don't have the authority to determine the status of slavery inside their borders? The way the original 13 states did. It's called the equal footing doctrine. All states, old and new, are equal. They are equally sovereign, and therefore they must have equally the same prerogatives. And that means you can't say ex ante, ahead of time, you can't say you may be a state, but only if you accept slavery, or only if you don't accept slavery. That the union of these states rests on an equality of rights and advantages among its members, and that whatever destroys that equality tends to destroy the union itself, and that it is the solemn duty of all to resist all attempts to discriminate between the states and extending the benefits of the government to the several portions of the union. Notice, in the italic comments in the notes here, I point out another major oversight. The Constitution is really unspecific about how states will be admitted and created. It's where it says we can have new states, but it doesn't answer any other particular question. For example, if we seize territory from a place called, let's say, Mexico, do we make that territory a state, or do we first need a treaty with Mexico ceding the territory to us? Can a simple majority vote of Congress make Canada part of the United States? Just think about that question for a while. It's just not well worked out. It's another one of those oversights in the Constitution that is not carefully specified. So that's the situation. That's the question and the problem. Here's Taney's opinion. And it's in 2 parts. First, the question of federal court jurisdiction. Can federal courts hear this case? And his answer is going to be no, at which point you could say, okay, you're done. You're not going to hear this case. That's it. Everybody go home, right? Oh no. Taney decides to use this case to add a second part where he says, and by the way, the Missouri Compromise of 1820 was unconstitutional. One of the authors of your textbook, Mark Graber, has a superb book called Dred, Scott, and the Problem of Constitutional Evil. The book argues very persuasively, to my mind, that Taney was right. Which, of course, forces us to confront the possibility that a correct interpretation of the Constitution leads to an evil result, hence the title Constitutional Evil. Whatever made you think that anything in the U.S. Constitution is always necessarily good? That's Graber's provocative question. But now, let's just look at the case. So, Taney's argument that former slaves are not citizens. And I want to give you a hypothetical to help illustrate this point because I think it can be confusing. Supposing it's 1787 and the Constitution is being sent out to be voted on for ratification. The people of Canada wish to have a vote. They say, we're affected by what happens here. We want to be allowed to vote on ratification. Massachusetts says, great, do it. Virginia says no. That's a disagreement that can be easily resolved. If you say, yes, the Canadians get to vote, then the Virginians are being bound by a version of the people they never agreed to be part of. Does everybody get the argument? You can't force the people in one state to accept Canadians or French people or black people as part of the national people of which this is kind of a bizarro world version of the Federalists' theory of constitutive power. It takes the idea that all power comes from the people, but instead of making that a theory that empowers the people against their governments, it becomes a theory that excludes whomever is not considered part of the people according to some set of tests, and that tests we're getting to. It will be observed that the plea, that is, the plea in the case that's being heard, applies to that class of persons only whose ancestors were Negroes of the African race and imported into this country and sold and held as slaves. Why is that important? People often misrepresent this case. They often say it's about black people. It's not. Tawney recognizes, and the full opinion is 224 pages long. Be thankful you have excerpts. But in his discussion, Tawney recognizes that a black person from Africa can be naturalized under federal law, and boom, they're citizens, no problem. It's not about that, he says. It's about being descended from slaves. The only matter in issue before the court, therefore, is whether the descendants of such slaves, when they shall be emancipated or born of parents who become free before their birth, are citizens of a state in the sense in which the word citizen is used in the Constitution, i.e. Article 3. Article 3, again, gives federal courts jurisdiction over suits between citizens of different states. All right, so we've made the question specific. Does Article 3 give jurisdiction over suits brought by people who are either freed ex-slaves or the children or grandchildren or great-grandchildren ad infinitum of that class of people? To answer that question, Tawney turns right back to the very, very beginning of our discussions about constituent power and who are the people. And as you listen to this, it's like Chase and Wilson on a bad acid trip. The words people of the United States and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our republican institutions, form the sovereignty and hold the power and conduct the government through their representatives. They are what we familiarly call the sovereign people. Every citizen is one of these people and a constituent member of this sovereignty. All right, so our problem is defining the people. All of the ramifications that carries for theories of representation, theories of legal rights, theories of citizenship. There's a great deal wrapped up into this, and he recognizes that fact. And here he introduces something we've never seen before, originalism. This is the first appearance of originalism in a U.S. Supreme Court case, as far as I know. It is not the province of this court to decide upon the justice or injustice, the policy or impolicy of these laws. The decision of that question belonged to the political or lawmaking power, to those who formed the sovereignty and framed the Constitution. The duty of the court is to interpret the instrument and administer it as we find it according to its true intent and meaning when it was adopted. A, where does that come from? The answer is contract law. This is the basic rule about how to interpret a contract. B, why do I say this is originalism? Because unlike all the previous references to history, lots of people refer to history. Every justice that I know of frequently refers to history for guidance. Tawney's making a different claim. Tawney's claiming that the courts are bound by the historical, not just informed, bound by the historical understanding. That the function of the courts is to find out what that historical understanding was, and that's the end of the question. That is an argument we have not seen before. We won't really see again in a clear way until about 1980. It kind of falls out of fashion after this. You can kind of see why. But this is the first appearance of historicism, or if you like, originalism. And then he goes through this kind of weird, distorted version of Ware versus Hilton. Remember in Ware, going through the different stages? They were sovereign states after the Declaration of Independence, and they were this under the Articles of Confederation, then with the adoption of the Constitution, everything. Remember that? The different stages of sovereignty? Here's his version. Previous to the adoption of the Constitution, so under the Articles of Confederation, every state had the undoubted right to confer on whomsoever it pleased the character of citizen. Right? There was no federal citizenship law. The Constitution gives Congress the power to make laws about naturalization. Prior to the Constitution, it was up to each state, and each state can make anybody they wanted to a citizen of their own state. But this character, of course, was confined to the boundaries of the state and gave him no rights or privileges in other states beyond those secured to him by the law of nations. So Massachusetts could make 5-year-old citizens if it wanted, or aliens, or tourists, or anybody else, but that didn't mean that they had any prerogatives in other states. The Constitution, in addition to creating a federal law of citizenship, has the full faith and credit clause. The Constitution has a clause that says each state is bound to recognize and give effect to the acts of other states. That becomes problematic. Moreover, with the adoption of the Constitution, the states did not surrender this right. It remains the case to this day. So, for example, in California, some areas in California allow aliens to vote in elections, resident aliens. on the grounds that they're affected by the outcome and they live in the city and so on. So, and they can do that. Nor have the several states surrendered the power of conferring these rights and privileges. Each state may still confer them upon an alien, or anyone it thinks proper, upon any class or description of purposes. So each state can do what it wants. So what's the limitation here? Why is that important? Because if each state can do what it wants, then the crucial thing to recognize is that the actions of one state cannot affect another. It can't be a federal thing. Does the Constitution of the United States act upon him whenever he shall be made free under the laws of a state? In other words, if Massachusetts makes somebody a citizen, does that mean that person is entitled to the national Constitution's protections and raised there to rank of citizen and immediately clothe him with all the privileges of a citizen in every other state and its own courts? The court thinks the affirmative of these propositions cannot be maintained. That can't be right. Now, I've added a piece that's not in the. This is on Canvas anyway. I've added a piece that almost no one ever reads. I've never seen this in a casebook, but I find it incredibly informative. Tawny goes into this long discussion of a weird case called Legrand versus Darnell, and he seems to think it's really important, and I think he's right that it is really important, but you have to look at it really carefully to see why. So Legrand versus Darnell is this previous federal court case in which a freed slave claimed jurisdiction. So in that sense, at least, it's some sort of precedent. It wasn't a Supreme Court case, just a lower federal court case, but it's precedent for the question, at least. It was about a land sale. Darnell is a freed slave. He inherits property in Maryland. He sells it to Legrand. Darnell is now a resident of Pennsylvania. This suit is collusive. That is, Legrand and Darnell aren't fighting with each other. They go to federal court to have the title clarified. Is this a legitimate sale? Just to make sure it's settled, because the question isn't clear. So the question is, can this suit be heard in federal court? Can freed slave Darnell, living in Pennsylvania, file suit against someone from Maryland on a question about a contract for the sale of land? Got it? The answer has to be no. Consider, says Tawney, this case strikingly illustrates the consequences that would follow the construction of the Constitution, which would give the power contended for to a state. Imagine if the father of young Darnell had manumitted, that's freed him in his lifetime, and sent him to reside in a state which recognizes him as a citizen. All right, so we imagine that Darnell is freed not at the death of his master, but I'm not quite sure why that made a difference, honestly, but Darnell's owner frees him and sends him off to Pennsylvania, right? Never mind lawsuits. He might have visited and sojourned in Maryland when he pleased and as long as he pleased as a citizen of the United States. The state officers and tribunals would be compelled by the paramount authority of the Constitution to receive him, to treat him as one of its own citizens, without respect to the laws of Maryland, although such laws were deemed by it absolutely essential to its own safety. The slave states viewed their laws prohibiting freed slaves and the children of slaves from being participants in their polity as essential to their survival. That's police powers. Fundamental sovereignty of a state, the ability to preserve itself, its safety, its public order. This theory that Dred Scott is claiming, if we accepted it, if being made a citizen of a state made you a citizen of the United States, would mean that free blacks could enter into slave states and they would be required, obliged, to abandon all of their laws about how to treat free black people, even though in their view that threatens their survival. That can't be right. And I think that illustration, that Darnell case, is where Tawney really makes his position clear. Because if the question of slavery is ever made national, then the game is up. Then this business of having some free states and some slave states, and well, it's a compromise, and well, we have the Fugitive Slave Act, it says you have to, none of that matters. And again, why? Because of originalism. It is true every person, every class and description of persons who were at the time of the adoption of the Constitution recognized as citizens became also citizens of this new political body. It becomes necessary then to determine who were citizens of the several states when the Constitution was adopted. To do this, we must recur to the government institutions of the 13 colonies. Notice what's going on here. The meaning of the Constitution was set at the time of the Declaration of Independence. This is not a question of what the Constitution did do so much as what it can do. A separation of questions we've seen at least twice before. Remember Martin versus Hunter's Lessee, and also Ware versus Hilton. We must inquire, therefore. So he goes to the Declaration of Independence. He describes it as a statement by the people who suffered injuries and created a new sovereign. This is a moment of constituent power, after which the sovereignty remains in place. We can't change who the people were. The people are the ones who declared themselves a separate nation. In the opinion of the court, and he goes through a whole slew of stuff. And he says, sure, some states, like Massachusetts, for example, gave free black people rights. Some states gave aliens, people from other countries. Aliens doesn't mean people from other planets. It means Canadians, Brits, Frenchmen. Some states gave aliens rights, and they're free to do that. But he says there was no obligation to do that. It was an act of generosity. By contrast, the people who were the original citizens are the ones who were entitled to be treated by their states as citizens. So in other words, only those citizens who were recognized as citizens by all the states were national citizens. It is the opinion of the court, the legislation, histories of the time, and the language used in the Declaration of Independence show that neither the class of persons who've been imported as slaves nor their descendants, whether they become free or not, were then acknowledged as part of the people, nor intended to be included in the general words used in that memorable instrument. How do you solve the problem? All men are created equal, blah, 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 blah. People? Answer, they're not part of the people. If you want to extend this to say that they're not men, you could. One key phrase here is the several states. Let me go back to a quotation that I read a moment ago. Every person and class and description of persons who were at the time of the adoption recognized as citizens in the several states. What he means by several states is all of them, as opposed to only in one of them. So the citizens of Massachusetts who became US citizens are only the ones whom Georgia would have recognized as citizens, and vice versa. But that's only the first part. As I've said, Taney's argument makes it clear that if the question of slavery is a federal one, it explodes. And he is perfectly willing to follow that to its logical conclusion, which is that every attempt to make it a federal one must be unconstitutional, starting with the Missouri Compromise of 1820. So the Missouri Compromise of 1820 said, in all territories ceded by France, the United States, also known as the Louisiana Purchase, which lies north of 36 degrees, et cetera, slavery and involuntary servitude shall be forever prohibited. Right? It's the Mason-Dixon line, applied to the territories procured in the Louisiana Purchase. All right. Question, could Congress do that? Answer, no. Why not? Originalism again. The word territories in the Constitution, says Taney, referred only to those areas held as territories as of 1787. It did not mean that there could be any future territories. The word territories, says Taney, was an ad hoc provision dealing with an immediate specific need, and it was not intended, as originally understood, to contain the possibility of other areas becoming territories in the future. In the judgment of the court, that provision, that is the one giving Congress authority over territories, has no bearing on the present controversy. The power there given, whatever it may be, is confined and was intended to be confined to the territory which at that time belonged to or was claimed by the United States. It was a special provision for a known and particular territory and to meet a present emergency and nothing more. And in fact, Taney takes this further. Right? If that's true, right, then there can be no further territories. There can't be any federal territories. The only way the United States can expand physically is to make new states. It can't hold territories like, Puerto Rico. There is certainly no power given by the Constitution to the federal government to establish or maintain colonies bordering the United States, or at a distance to be ruled and governed at its pleasure. This is the small d democratic language and the small r republican language rejecting empire. The U.S. Constitution makes us a republic, not an empire, to cite a slogan that was very popular a few years back, and is attributed to Benjamin Franklin, among others. So the whole idea of having new territories is just wrong. And therefore, Congress can't have any authority over them. Well, what about the necessary and proper clause in McCulloch, the broad interpretation that says Congress can do whatever whatever specific things are required to carry out its general grants of power. The words needful rules and regulation, that's the phrase that is used in the passage giving Congress authority to make rules for territories. The words needful rules and regulations would seem to have been cautiously used for some definite object. There is certainly no power given by the Constitution. They are not the words usually employed by statesmen when they mean to give the powers of sovereignty or establish a government. Therefore, this is a question of state law determination. That is, anyone who enters a territory carries with them the property rights they had under the laws of their state, including, of course, slavery. Taking this rule to guide us, it may safely be assumed that citizens of the United States who migrate to a territory belonging to the people of the United States cannot be ruled as mere colonists. The fact that an American enters a territory doesn't mean they suddenly lose all the prerogatives they had when they were in their home state. Specifically, state control over property ownership rights. And now you can see why the model of rights as property is so powerful, as opposed to the model of rights as restraints on government. The distinction between those two is so powerful. Whatever it acquires for the benefit of the people of the several states who created it. It is their trustee and charged with promoting the interests of the whole. Upon these considerations, it is the opinion of this court, the act of Congress, which prohibited a citizen from holding and owning property of this kind in the territory of the United States, is not warranted by the Constitution and is therefore void. So much for departmentalism or popular constitutionalism. On this question, Taney is asserting strong judicial supremacy. We, the Supreme Court, find that the Missouri Compromise, which has been in operation for 40 years, on the basis of which states have been, formed and territories is void and is unconstitutional, and we declare it void. Curtis writes a famous dissent. He points out that not only were free black citizens in Massachusetts, some of them participated in the conventions that ratified the Constitution, which, according to Curtis, makes this historical argument garbage. And it's frankly hard to disagree. I think, though, what's more important is that Taney is, even saying this, is correct. That the theory of popular sovereignty, captured in the high federalist notion of constituent power, as a single national people, falls apart when you address the question of slavery. If all states have been slave states, that would have been fine. I don't mean fine. I mean, that would have been logically coherent and consistent with the idea of constituent power. If all the states had been free states, that would have been logically consistent and coherent with the theory of constituent power. But if it's a national people creating a national government with national powers, that means that at some point, in the courts, in the Congress, in the presidency, those national powers are going to address the issue of slavery. And that can't happen. So, when I say Taney was right, I mean several unpleasant things. One, he is not wrong that even in states like Massachusetts, the fact that free blacks were given full rights doesn't mean there wasn't an era of this is a gift that we, the real people, give you. That was absolutely part of the kind of attitude and the thinking. Just to give you an example, in 1850, the state of Illinois adopts a new constitution which bars free blacks from settling in the state. Lest you think this is a purely regional, 1850, lest you think this is a purely regional question. Taney is also not wrong that the high federalist theory of a single national people falls apart when confronting the problem of slavery. And he's also not wrong that under the equal footing doctrine, under questions of property law, the Missouri Compromise is very, very hard to square with the provisions of the Constitution that would otherwise be enforced. And we will leave it at that. That's it. Next comes the Civil War. Actually, I'm not sure that's the next lecture, but that's the next thing. That's what follows from Dred.